Tech Revision with Mrs. Swanee Pooh.
Hi everyone, this video covers the topic of intellectual property rights. It's chapter 24 in the revision guide, and the chapter is called Protecting Designs and Intellectual Property. So what do you need to know for this chapter? You need to know, firstly, what intellectual property actually is, or sometimes shortened to IP. You need to know what all of these are. So these are all types of intellectual property rights. So copyright, unregistered design rights, patents, registered designs, and trademarks. And then you also need to know about something called open design, which I think is really interesting. So we're going to go through each of these, what they are, a bit of information about them, and some examples. So firstly, what is IP, or intellectual property? So intellectual property is a unique physical creation that is entitled to protection for its creator. So it's something, intellectual property, something that you have created and you are entitled to protect it to make sure it's not taken or used by anyone else. So why do we need that? Some of the rights are automatically gained, but intellectual property rights are the only legal way to protect your work from being stolen or shared without your permission. So it's basically to protect. It could be to protect an invention or a logo or the shape and style of something. So that's what intellectual property rights are. So let's go through each of the different types of intellectual property rights. So the first one is called copyright. It has this little logo. So you might see something that has a little C copyright sign at the end of it. And copyright is for these things only. So it's for books, photography, drama, music, films, TV, and software. So interestingly, it lasts 70 years. But you can give permission for others to use your copyrighted materials. So for example, if a film wanted to use a particular type of music, they would need to make sure that they had permission from you because you have copyright for that music. Or if in a book they were going to use some photographs, they would need permission to use those photographs. So that's copyright. The next one we need to understand, this one's a bit of a weird one, because this one is one of the ones that you don't register for. So it's design rights, and it's all to do with the appearance of a product. So it could be the shape, the materials, the way it's been decorated. And this one, you don't actually have to register it. It's not required. You get a 10-year coverage of it. So the unregistered design right lasts for 10 years. You might be thinking, well, how can you do that if it's not been registered? Well, you need to make sure that you keep things like drawings and records of your design so that you can prove if someone does take it within that 10 years that you have unregistered design rights to that product or that design that you've created. The next one is probably one of the most famous ones, which is called a patent. And the only thing that this can cover is the working parts of a product. So you can't patent the way something looks. You can't patent something that's been written. It's basically like something unique, and it needs to be a new innovation, like an invention, basically. So so like I said, it could be something like a new design for car suspension. You could patent that. So what you do if you think you've got something new and you want to patent it or patent it is you would contact the Intellectual Property Office, and this is sometimes called IPO, and that would grant you legal rights or a patent for your invention. And you would need to give really detailed drawings like this, and this is actually the patent for Lego. I've actually got this printed on my wall in my living room because I love it so much. Yes, I'm that cool. And it gives you protection for 20 years for the patent of the technology or the unique mechanisms or whatever, okay? So that's what a patent is. It protects the working parts of a product. very, very famous legal battle that went on was when Apple sued Samsung for infringing on their iPhone patent or patents, and they were awarded 539 million for basically copying their touchscreens, all their different things that they'd patented in the iPhone. Samsung were judged to have copied them, and that's how much they got sued for. Next couple here that we need to know about are registered designs. So this is the one like unregistered design rights. This is when you actually register it. So again, this one applies to the appearance and the decoration of a product, the shape, the colors, the style. It doesn't cover anything else. It doesn't cover like the internal working. It's just the appearance. Sometimes it has this registered design logo next to it. And if you register it, you get it registered for 25 years. And you do very similar to what you do with a patent. You submit illustrations of the product and you submit that to the Intellectual Property Office. So this is registered designs. So one big issue that still happens all over the world is there's a massive trade in fake design label products. So you might go abroad somewhere and pick yourself up a Chanel bag, which is clearly a fake, and that is an infringement on a registered design. And people can get penalised, but it's obviously very tricky to track that, so it's a bit of an issue. But that's what registered designs are. You have them for 25 years, and it covers the appearance and decoration of a product. Right, the last one that you need to know is this one, which is trademarks. Quite often they're put on logos. So companies can trademark a word, a phrase, a colour of something, or graphics. So I know that the orange colour that Ford used on some of their cars was trademarked. The Starbucks logo, the Nike logo, the Nintendo Switch logo, these examples here, you can see they've all got TM, and absolutely minuscule, you can't really see it. They are all trademarked logos. The reason that they protect them is they are instantly recognizable. They make a brand stand out from its competition. And quite often, if a customer sees that brand, they are loyal to it, they will purchase that product. So it is the identity of a brand. A logo is very, very important. So that is what a trademark is, and it quite often has this, well, it always has this little TM logo there. Right, so I've seen before in an exam that they can ask you about how a product could use all four types. So counting registered design and unregistered design is the same thing, kind of. All four types of intellectual property rights. So this one is a really good example, this Bic pen, which is called the Bic Atlantis. It actually has all four different types of intellectual property rights on it. So there is a patent in action for the ball ink delivery system, which is called the Laszlo Biro ball ink delivery system. That is patented. So they will have submitted some complicated exploded drawings of the internal workings of this pen to get that patent. They then have a registered design for the S curve. I don't know where that is, but it must be somewhere around here. Oh, there it is there. The S curve on that kind of like the grip, the barrel shape of the pen, and some other aesthetic features. So that's all about the look of the product. So they have the aesthetics of the product is they are registered designs. They have then trademarked the logo and the name Bic and the name Atlantis. So those are both registered trademarks. And the last one, which might catch you out, is they've copyrighted all the text on the packaging. So think on the back, all of the safety instructions, all of the information on the back, that is all copyrighted. So here you can see this product uses all of the different types of intellectual property rights. So this is quite a good example. Okay, so I'm going to get you to pause here and have a think how this product could use all four of these different types of intellectual property rights. So think about on this bike, very sophisticated, cool looking bike, what actually could be patented, what could be copyrighted, what could be a registered design, and what could be trademarked. So pause and have a go. Right, hopefully you paused and had a think about those 4 different things. I'm going to make some suggestions about the types of things you could talk about. Obviously, patents is all about the workings of the product. So it could be that there's quite a unique suspension system going on. So that could be one thing that's patented. There could be some very clever gearing. I don't really know. There could be a clever way of adjusting the seat. But notice that all of the things that I'm talking about are mechanisms or the way the product works. So those could be patented. Right, what's going to be copyrighted? Let's go here next. This one's quite tricky. It would be things like the instruction manual. All of the information on the instruction manual would be copyrighted material from that company. So that one's relatively easy. The registered design or the design rights, this is going to be the shape and the style, the use of colour. So that is all what you could register for design rights. So it's the appearance of the product. So that kind of use of black and red, this quite unique shape of the actual like frame of the bike, which is awesome. It's probably been made from carbon fibre. So that's what you could do for a register for the design rights. And the trademark is going to be the logo or any other sort of text on the bike. That could be trademarked. Okay, so the last thing that we need to talk about is the term open design. So here's a question at the beginning. What is meant by the term open design? Explain how open designs can benefit society. Could come up in the exam. Okay, seen some examples before of open design, like on water pump. There was a water pump exam question one time. But open design basically means a communal, altruistic approach to design. So altruism, as well as being a Taylor Swift lyric, is the principle and moral practice. Basically, you care about the welfare or happiness of other human beings or animals. So your approach to design is trying to make something that's going to help people. So your intent is to produce products and systems for the good of society rather than for the money. Okay, so rather than financial reward, you are producing products that can help people. So quite often those could be in developing countries, people in poverty, things like that. So all intellectual property rights are rejected, and collaboration, so working together and sharing, is encouraged. So as an example here, this bike is an open design that you can download and create it yourself. It encourages sustainability. And this phone here, which is called the Fairphone, I'm going to talk about that on the next slide a little bit, is an open source software that you can edit and change yourself. So here's some other examples of open design, really good examples actually. The first one is an organisation called Practical Action. You'll find these examples in the revision guide, but I just thought they were really, really good. Practical Action, if you Google it, they promote something called technology justice, which I guess means that everyone should be able to have access to these, these different things that can help in life. Things like water purification and access to clean water, being able to produce your own food, all that sort of stuff. So this organisation produces or creates products and runs projects to challenge poverty in developing countries like Africa, India, places like that. The designs are freely copyable, so they are open. They are open for you to edit, to play around with, to tailor to your individual need. And quite often the designs are life improving. So this one is basically a water pump. You can see it's got a solar power kind of component on the top there. Other things that they've created, things like plows and aerial ropeways, which can make really remote places more accessible. So Practical Action is a really good example of an organisation who uses open design. Another really good example is this product called the Fairphone. It's open source software and it's modular. You can edit and change bits around it. It's easily maintained and upgraded. And this is challenging the idea that we should be throwing away mobile phones every couple of years. But the open source software means that you have control of how your phone runs, which is quite unique in a way, designed so that you'll hopefully hold on to it for longer. And the last example, this one, shipping containers, which is really interesting. You might not think so because it's about shipping containers. But in the 1950s, the company or person who invented the shipping container basically leased the patent for it for free. They made it free. They said that anyone can access it. Now, the reason they did that is that they wanted to help facilitate freighting and use of shipping containers worldwide. So if they had patented their unique design, it would mean that the kind of the way that it's been set up around the world wouldn't have been able to happen, because you might have one shipping container that is one size and then the next one would have to be slightly different, because otherwise it would go against the patent. So making sure that everyone was able to build shipping containers in the same way made it a lot easier for the logistics of like worldwide transport. So it made it better for everyone. Okay. So that is open design. That is all intellectual property rights. I hope that was useful. See you on the next video.